Welcome back, brothers and sisters. I am Braden. This guy's Tim, and this is The Second Legacy, and thank you so much for stopping by. On today's show, we're going to dive into the new assault weapons ban from Illinois that has been canceled, then uncanceled, then now recanceled, and finally uncanceled again in the last step before the SCOTUS. This is a seesaw of freedom versus control, and we have got to break it down right now. Everything will be linked in the description box below, and if you guys like this content in this format, please like the video, subscribe to the channel, and turn the notification bell on. We need as many of you as we can to get into the fold to pass this information and the Second Amendment along so we have a common cause, and thank you in advance for your consideration. The content today is brought to you by BulletSafe. I'm going to say a quick word from them, and then we are going to hit it. Now, the vest you're seeing me wear is from BulletSafe, and they've sponsored these videos. BulletSafe is on a mission to be the #1 provider for safety equipment such as this for not only the civilian, but also the security market. Now, the VP3 that I'm wearing comes in at $299.97, which makes it completely affordable and provides up to or better than Kevlar protection. This thing is NIJ level 3 tested. You are talking about up to 44 Magnum stopping on this bad boy. They've made it concealable, discreet, comfortable, and breathable. It's modular and upgradable, and in comparison to previous models, it's 50% thinner and 25% lighter. As you can see, I'm wearing it in the filming of this spot, and it is not even adding to any of my dexterity whatsoever. This is something very concealable, and if you're in the market, this might be something just for you, and thank you to BulletSafe for making this content possible. All right, so thank you again to BulletSafe, but Tim, my man, we've got more action from Illinois. How are you doing? And then we're going to hit this, my man.
Well, I'm a little too close to Illinois. It's
you are
like a half hour from me. I used to live over there. It was a mistake. I was just looked at a map. I'm like, oh, you know what? I can find a job in Chicago. I moved to Illinois in the 90s and walk into my first gun store and I say, hey, can I take a look at that gun? They say, hey, can we see your FOID card? I'm like, hey, what's a FOID card? And they're like, hey, you're going to go to jail if you don't have one. I'm like, hey, I got a whole apartment full of guns. And I'm like, okay, start looking at Wisconsin and Indiana, and wound up in Indiana. But wow, what a crazy state.
Statute of limitations still applies for that confession you just made on Second Legacy, right? I'm pretty sure we're good.
Oh, absolutely. They can come try to get me out of Indiana if they want to. I don't think it's going to work too well for them, but I mean, whatever.
Okay. All right. Hey, as long as you're clear, I'm clear.
Yeah.
Well, as long as we're all clear, because I'm in Georgia and, I'm still somewhat free. So got that going for us. But you know what? Let's talk about what's going on in Illinois, Tim. Mr. Producer, let's set this up. Could you hit #1 for me and then follow it with 2 and 3? Federal appellate court puts hold on ruling that blocked enforcement of the Illinois gun ban. So roll #2 for me real quick, and then we're just going to set this up all at one time. Springfield, a federal appeals court in Chicago on Thursday, put a hold on a ruling by a lower court judge that blocked the enforcement of the state's ban on many high-powered firearms and large-capacity ammunition magazines. And finally, the U.S. 7th Circuit Court of Appeals decision stops last week's ruling by U.S. District Judge Stephen McGlynn from being in effect until further notice. Appellate Court Judge Frank Easterbrook, though, allowed lawyers in the case to file more briefs in response to the decision. So, this is very high level, and there's a few things that I kind of want to set some parameters as we go into this. First of all, there's a lot of cases coming out of Illinois in response to city-level bans, like one in Naperville, which Justice Comey Barrett is involved in. Then you've got these, which are statewide, which is the Illinois assault weapons ban, which is what we're talking about. This was signed into law by J.B. Pritzker this year. Now, at the high level, this has now been reinstated at the 7th Circuit Appellate Court. So what that means is it's pending SCOTUS approval if they were to take it. And that's kind of where we're sitting. So from your perspective, with this seesaw, Tim, what are you seeing here? Because there's so much going on.
Well, it's funny that back and forth actually even took place in Illinois, given where most of the justices, I think, would stand politically. So I was really excited when they, struck it down. Well, they didn't strike it down, but they put a hold on it originally. Right. And then, like you said, they went back and forth, and now we're back to, it's going to go forward. I guess that's the only part of it that's surprising. I'm not surprised by Illinois passing such a law. I'm not surprised that they finally decided, yeah, sure, you can do it. And I'm hopefully pretty sure where the SCOTUS would stand on this should they decide to take up the case. My only concern is that they perhaps won't. Like, for whatever reason, they may not think this is the one for them, that it doesn't address enough of the issues nationally, that the Supreme Court can be so funny because they take such a small percentage of the cases that come before them or they're proposed.
Oh, yeah. I think it's 3%. I think that's the number.
Really low. And they're pretty selective. And it's not that they agree with the ruling many times. It just, they don't think it really is ready. They don't think it's the right case to make the decision that needs to be made. And so I don't know where this is going to fall, obviously, on that scale. But if they do take it up, I do think I know what the outcome will be. And they're going to say, yeah, this is wholly unconstitutional.
Yeah, and that's the piece that I kind of wanted to get into. Now, of course, there's a little Easter egg in here for you guys who are watching, because the arguments from the actual state attorney general we're about to get into, oh man, they are they're comical gold. But to kind of wrap up that point about the Supreme Court, I think that's where it's most interesting, right? Because you've got, over time, you had the bluest deep bastions. They were doing assault weapons ban. You had the New Yorks, you had the Connecticuts, you had California. Now you've got Oregon, now you've got Washington, now you have Illinois. You have all of these different states that are lining up to infringe upon the Second Amendment at the exact same hive mind mentality of ban this platform, ban these magazines, and make sure you do it in this way. It's very reminiscent of when they started passing the shall issue stuff, because it passed in New York, passed in California, and every other state that is prone to gun control went the exact same route. They followed the exact same path, and then Bruin happened.
Yep.
I'm seeing a Bruin setup here. It's what it looks like across the board, because 10 states now have assault weapons bans.
Yeah, that's what I'm hoping. I hope the Supreme Court takes a look at this, because the states are doing this obviously to defy the Supreme Court in their latest ruling 100%. With the Bruin decision, right? Because it does fly in the face of that decision. And so, you know, I tell people this all the time. Just because you get a favorable court decision doesn't mean it's going to change anything right away, because the courts really have no way. It's not like the Supreme Court has a law enforcement arm that can go into Illinois and say, hey, you can't be doing this, stop it, you know? Right. So you have to keep dragging them through the courts and getting decision after decision until you finally force them into compliance.
You close every single door, right?
Right. You just have to go, because every argument they make, you got to take it to court and you know, tear that argument apart. Illinois was the last state in the union to issue a concealed carry permit. They were drug kicking and screaming through the courts. And finally, McDonald said, you know, yeah, you're going to have to do this. You can't deny the citizens the right to carry a firearm. And so, you know, I do hope that Bruin is the linchpin in all this. But again, it might not be the case that they need, because we have other states that have done the exact same thing, and the Supreme Court hasn't done anything just yet. So I think they're waiting for the arguments to be such that they think that they can tackle this and get that one decision that finally puts us to bed and stops this practice of these states, you know, doing whatever they want in defiance of the Constitution and Bill of Rights.
Well, and I think the SCOTUS, that there's so many different nuances to that, and that's what we're really just going to have to wait and see, to be quite honest. But that's another conversation for another time. Right now, I've got to show you, Tim, I got to get your reaction on what the state attorney general in Illinois actually argued and the judge accepted. All right, so Mr. Producer, enough of the wait. Reveal number 6, sir. Quote, enjoy, Tim. The massive amount of energy imparted by AR-15 rounds is far more than needed and counterproductive for self-defense. And there's more. Quote, in fact, assault weapons are inherently dangerous in a home's defense scenario because they pose substantial risk to individuals in adjoining rooms, neighboring apartments, and other attached dwellings. They actually argued that in court.
Yeah. So clearly they haven't watched any of my videos, any of other YouTubers' videos where we actually discuss this. I think Grantham actually just did a video talking about drywall and things like that. So look, they're trying to argue that these things are wildly overpowered. They probably shouldn't look at deer rifles. In the state of Illinois, I'm pretty sure, because it's set that way in Indiana and most of the Midwest states, 223 5.56 is not even legal for deer hunting. Why? Because it's considered inhumane. Why? Because it's not considered powerful enough. If you take a look at the U.S. Army, they've been complaining about the M193 and M855 rounds, 5.56, 223 forever. And they just recently adopted the M7 rifle, which is a 6.8 by 51, which is in essence a big bore battle rifle, even more powerful than 308 Winchester. Why did they adopt that? Because they don't think that the 5.56 has the range and lethality that they need to effectively fight enemy combatants. And so when you're in a fight for your life, the 5.56 is just okay. It's not some death ray. It's not some incredibly powerful rifle cartridge. It is what's called an intermediate cartridge. What does that mean? It's not quite a pistol. It's not quite a rifle. It's somewhere in between. Matter of fact,
it's originally a varmint round.
Yeah, the South Koreans considered a carbine, considered a submachine gun. What's a submachine gun? It's a pistol-calibered machine gun. That's how they view their rifle, that their carbine that has a collapsible stock. And so the K2, I believe it is. So, other militaries don't see the 5.56 as some death ray. Our own military doesn't see it as some death ray. The civilian population that actually uses them will choose a different cartridge when they're out hunting and things like that. So it's just okay. And yet they're trying to paint it as some incredibly powerful. You shouldn't own this because it's a weapon of war and it can knock down schools and orphanages and take satellites out of orbit. It's just unbelievable. They don't even have to hit you with it. If it just comes within the same zip code, it'll suck the soul right out of your body. It's the current version of the 45 ACP. And so it's just that their arguments don't hold water, and it's laughable to anybody in the know. But that's just it.
Right.
Nobody is in the know that they're targeting this towards. The average American is going to look at this and go, oh, yeah, you can't have that.
Right. Well, but that's the interesting thing about this, and one of the reasons I was excited to get your take on it is because obviously everyone watching this, well, I can't say everybody, but a lot of people watching this would know that that's crap on its face. That's easy to see. That is easily disprovable. If you've ever been to a gun range, you know that that is not true. I mean, if you've ever experienced this platform with that round, what they're describing is completely in a different reality, right?
Well, I think it did give a journalist in New York City PTSD when he fired one for an article. Yeah. So they are pretty nasty. Yeah.
Yeah, it's pretty crazy. It's pretty crazy. But the interesting part, but the thing that's so fascinating about this is they actually used this in court.
Yeah.
And in one sentence, like literally, they contradicted themselves in this first sentence. They say, in one sentence, the energy dump is beyond the pale. It's more than you would ever need for self-defense. But at the exact time, it's counterproductive and not useful for self-defense.
Right. Because self-defense, you're not trying to kill the guy that's trying to kill you. Oh, no. You're just trying to wound him.
It doesn't make sense.
Yeah.
At all. And then they transition to penetration issues or over-penetration issues of going through a house when you're talking about an intermediate cartridge, which, again, if you have any experience, any testing, there's so many variables. In Vietnam, if a 5.56 like actual projectile hit a branch, it would go off askew into the wild blue yonder. That was actually one of the complaints that the GIs had. The 7.62 coming from the Chinese-made AKs went right through. And there's so much easily refutable information. It's mind-boggling that they actually do this. It's just,
but you know what? They can say anything they want in court. I see this all the time. I like to watch those various YouTube channels like Audit the Audit and stuff like that to talk about law enforcement, talk about criminal cases and things like that. And you see lawyers lying in court all the time. And then it's up to the other opposing attorney to point out the lies and convince the jury that it's a lie.
It's mind-boggling.
It is. And
it's mind-boggling.
It's crazy. And there should be some sort of a punishment for purposely propagating a lie in court. I mean, it's illegal to lie to the FBI. It's illegal to lie in all sorts of, legal areas. Why is it okay to lie in court with something stupid like this?
You know what? Honestly, I don't know, but that's a conversation for something else because that is not.
I'm not more into giving government more power and charging people with more crimes, but I mean, it's just it's just silly to me that this just goes on and there's no recourse for holding these people accountable for the bold-faced lies they know they're telling. They know they're telling. They have to know
it's 100% manipulation, but I would be remiss if I did not bring you the other part of the argument, because that was just the fun part with the energy dump and the whole penetration issue. Now I got to bring in some Heller, some Bruin. This is going to be great. Let's break into this. Mr. Producer, number 5, please, sir. In its motion to delay the implementation of McGlynn's ruling, who was the prior judge who ruled it or put it under stay, Raoul's office argued that the judge, quote, failed to decide whether assault weapons are bearable arms commonly used for self-defense. I know you're chomping at the bit. Bear with me. Raoul's office also argued that McGlynn's ruling failed to meet the burden in Bruin that the banned weapons were covered under the plain text of the Second Amendment protecting the rights of the plaintiffs to carry firearms for self-defense. Raoul's office argued that many of the banned weapons, such as AR-15 models, have similar capabilities as military-issued firearms and are therefore unnecessary for self-defense in a regular civilian setting. Where do you even want to start on that one? You want to open up with a soup du jour of Heller and Bruin, or you want to hit on the whole military-like? Because I thought they were military. At least the propagandists told us that.
If you go back to 2008 in the Heller decision, the Supreme Court said if a firearm is in common use by the citizenry, then it's protected by the Second Amendment. Now, 100%. I don't agree with the common use thing. I think all firearms are protected. I don't think there's any standard of common use, but the Supreme Court has said that. So what defines common use?
But that's the rules we're playing within, though.
Right. So let's go with the common use thing. The AR-15 is the most common, most sold, most owned rifle in current American home arsenals, if you will. The AR-15 is the most popular rifle on the market right now. If it isn't common use, nothing is. So
no, that's exactly right. And
right. I mean, the only other thing they would say next, what, Glocks aren't common use? I mean,
right.
But then the Supreme Court does this all the time, as many courts do. They'll say, well, there's a common use standard. Well, what is that common use? Well, we're not going to define that. It's like YouTube policies. Well, yeah, we got a policy against it. Well, what's the policy? Well, we can't tell you. So
Tim,
it's like, well, what is common use? Is it 2 million, 20 million, 200 million? What is common use?
What is it?
We still don't know. So we have to send it back to the Supreme Court every time for them to go, 19.2 million. If it was 19.3, we'd give it common use, but we're going to go back to, no, it's not common. I mean, how do they decide this? They need to stop with this ambiguity stuff and give us facts and hard numbers. Not that I would agree with them, but that's all they do. Is they're just setting it up so they can just bring future court cases to argue this over and over again.
Well, you're making a point, not in give me a hard quantifiable object. You're giving the point of, let's stop the subjective nature. It's an argue against subjectivity rather than something objective. I mean, it makes total sense. Yeah. But what would you say if I could use a court case out of the leftists of Massachusetts to bolster the point of common use? I think you would be intrigued, sir.
I would love
Allow me to share with the people. There's a case called Catano in Massachusetts. That's the last name of the case. In this case, and you guys can look this up, that's spelled Caetano. In this case, there was a stun gun, and the entire point was you couldn't use that. That's not bearable arms. And the Supreme Court of Massachusetts decided, well, it's actually common use because there were 2,000 of them in circulation.
Well, there we go. We have a standard. I'll take that.
There you go, 2,000. And in the United States, I believe the last figures were something around 25 million AR-15s.
Yeah. In the time that we've taken to record this episode, they've probably sold 2,000 AR-15s nationally.
That's possible. It's totally possible. And not to mention how many have been built in a PMF situation, which is terrifying.
Oh, yes.
Clearly.
Can't be building your own guns.
No.
We got to put a stop to that practice.
That.
Of course, I'm being facetious.
Of course. Well, the facetiousness, whatever.
What he said.
Whatever. You're stupid. You're stupid.
I have to throw that in there because in the comment section, Max anti-gun.
Of course. Right. I totally get it. No, I totally get it. But it's the nature of what we're dealing with in this Illinois assault weapons ban. And I think that's where they're going to get into trouble. Now, the case that we just rolled out, obviously, we're delivering in kind of a fun, tongue-in-cheek way, but the facts are the facts in this case. You've got a situation where something is clearly commonly owned by the population. You have a 2008 decision called Heller that says common use is protected under the Second Amendment. You have a Bruin decision which stacks on the Heller decisions that says the right to bear arms is a thing, and you can't say you can't do it. What are we talking about anymore? Like, why are we still doing this?
You know what's funny I saw an article on bearing arms this morning talking about an Illinois official saying that only handguns are protected for self-defense, not rifles.
State your case, sir.
Yeah, like, okay. And you know what I find funny about this? Now, I'm not advocating for a ban on handguns.
No,
That's
of course
not what I'm doing. Okay.
No.
I just want to point out the hypocrisy in their arguments and the hypocrisy in what they're trying to do, right? So we have assault weapons, looking at FBI statistics, anything that rifles of all types are only misused, I should say, maybe 360 sometimes per year in the United States for murder. Okay. Of that, maybe, they don't break this down, but maybe 100, probably far less, are of the assault type as the left wants to define them. Or the
it's insignificant. They don't even break it down, to your point.
Yeah, it's a statistic. Now look at me, I'm getting hung up on a word.
See?
I'm going to say it here. Statistical. Thank you. It's a statistical zero, right? I'm not downplaying the fact that people have died. Not what I'm doing. What I'm saying is far more people die by falling downstairs and drowning in their own swimming pools than die at the hands of some madman with an AR-15. It's just not common. And what's more common, there's over 6,000 misuses of a handgun to commit murder in the United States every year. Okay? But they're focusing on the less than 100. We can't have that less than 100. We're saying handguns are just fine. But if you're trying to save lives by banning things, why are you saying the firearm that's most used isn't the problem? The firearm that's least used is the problem.
Well,
hypocrisy, stupidity. They
can't
things. Make up their minds. They are all over the place. And it's just asinine.
So what you just brought up something that I think we can touch on for a second, because we're kind of wrapping this episode, but you just hit on something that is true. It's in FBI statistics. You can find it. The last time I saw it, I think the actual murders by handgun, I think the numbers was around 13 to 14,000. I think the numbers were provided in 2019, I believe. And then the rifles were 300. Hands, fists, bludgeons were more than rifles. So, I mean, again, going back to your point, this is not about minimizing loss of life. Any loss of life is terrible. But it goes to the point of undermining their talking points. If they go down the road of, well, it's about saving lives, well, you've got a lot of options there. Do we want to stay on the gun control debate, or we want to touch on the abortion thing? Nope. Okay, let's stay on gun control.
If they survive, if the child survives the vacuum cleaner, then we're going to be all of a sudden become concerned about their safety.
That's no. That's
well,
terrible.
Seriously. These are the people that advocate for literally, infanticide, but then they say that they're trying to save the children.
Correct.
I mean, well, it's like Jeffrey Dahmer trying to save his victims.
Right. That's exactly. So it's one of the things that I say on my channel all the time is the pillars of leftism, they cannot stand together. They cannot be in a pantheon. They can only stand completely by themselves. For example, they will talk about immigration. And they're only going to talk about that. And they're going to use talking points that are focus group tested, and that's what they're going to say. Then they'll go over to gun control, and they will say the exact opposite because you're in this pillar now. It's almost like a flow chart. If you're talking about this topic, then you go down this talking points. And if you're talking about this topic, you go down these talking points. And they all conflict. And it's fascinating to me that people don't call that out for what it is when you're debating somebody. Because for me, if someone says, we need to take all the guns away in a debate against me, and they say we need to take all the guns away to save, the children or save one life, it's worth it, then I'd be like, oh, so you're pro-choice. I mean, you're pro-life.
Yeah. So that's the standard. One life. Okay.
Okay. So that's the standard. Okay.
Let's just ban everything. I mean, and
cars. Right. And that's the thing is, I think kind of the second point to what we're kind of talking about is there's almost like an aversion to talking about that. Because when they make it about numbers of life, then they'll turn around and say, oh, you're making it about numbers of life. It's like, well, no, hold on. You just started this. Let's talk about this and actually use statistics to meet you on that point. But then they switch it on you and go back to emotion and make you terrible for using statistics. It's a very interesting observation. You guys, let us know in the comments field if you guys see that as well and what you think, because I'm curious to hear your thoughts on that. But anyway, that's, like I said, we could do videos on that all day long.
I know. But, I suspect that we're not done with the assault weapons bans in various states. They're going to keep pushing back every way they can. The anti-gunners are not going to give up. And even if we get a favorable court decision, they're going to continue trying different things. This is never going to end. And that's why it's so important that we stay politically engaged and active. Because it would be great to have that one Supreme Court decision that ends this for once and for all. But it isn't going to happen. It would be great if we could pass one law in Congress that would end this once and for all. They've tried. We've gotten very favorable court decisions. We've gotten very favorable legislative action done. But still, here we are fighting for our rights. It's going to go on indefinitely. And that's why we have to stay engaged. It's very easy to just get jaded. And I see this on the internet all the time where people just say, you know what, my vote doesn't count. I'm just sick of it. I give up. Well, you're giving up on liberty. You can't do that. What about all those folks that have fought in all the wars that we've engaged in over our history that laid down their lives for freedom? And you're saying, I give up. It just isn't worth it. I give up. You can't do that. We have to continue fighting. We have to stay engaged. So please contact your representatives. Contact the House of Representatives. Contact the Senate or your senators. Contact your local at the state level and at the county level. Contact your representatives everywhere, because all politics start at the local level. And it is absolutely imperative, because when they do something stupid at the federal level, the state can still protect you. So you have to be engaged across the spectrum. You can't just pick on the federal or focus on the federal elections, because that isn't going to get us where we need to be, because many of the battles we're fighting and winning are at the state level, at the local level. So anyway, I'm going to get off my soapbox on that one, folks. Thank you for watching. If you'd like to become part of our call-in show, there is a link in the video description below. Follow that link, get in the Google Doc, sign up. We'll contact you. We'll get you on the show. You can ask a question, or we can have a conversation about whatever's on your mind. But it is always related to the Second Amendment. Thank you for watching, and we'll talk to you guys soon.